This is the reading of your Week 2 Jury Charge Performance Challenge. Ladies and gentlemen of the jury, we are now at the part of the trial where it is my job to charge you as to what the law is. In doing so, it is necessary that I put in the record the general principles which are part of every charge, even though all of you may have heard it before. Paragraph. In this, as in all jury cases, you, as the jury, and I, as the court, have separate functions, period. It is your job to decide what the facts are in this case, period. And with respect to the law, what I say to you is binding upon you, period. And it is your duty to follow my instructions and in the best way you can, apply the law as I give it to you from the facts you find to be true in order to arrive at your ultimate verdict, period. If by chance you should have a different idea of what the law is, or perhaps what you feel it should be, you should put aside your own notions and conscientiously apply the law as I give it to you, period. In addition, if the law, as I give it to you, differs in any way from the claims made by counsel in their own summaries to you, then you will dismiss from your mind what either or both may have said to you about the law, which is against what I state to you the law is, period, paragraph. When I give you the law that is relevant to this case, it may be necessary that I point out to you the legal effect of certain facts or certain evidence, or that I suggest to you certain considerations which you must bear in mind as you go through all of the evidence that has been given to you in this case, period. Where I assume either of these things, you will listen carefully and give due consideration to what I say about it, period, paragraph. As to the questions of fact, you are to find what the facts are by a careful consideration of all of the evidence, and then upon that evidence give to each part of it the weight you consider it deserves in reaching your final decision, period, paragraph. It is my right to make comments to you as to the weight of the evidence, or as to the importance or lack of importance of your finding of certain facts from the evidence, period. But when I do give you those comments, they are just suggestions to you for you to look at and find in your own mind as to whether you agree or disagree with what I have said, period, paragraph. My chief concern with the facts in the case is to refer them insofar as it is necessary to make clear to you the application of the rules of law which are relevant in this case, period. If I refer to certain facts or certain evidence in this case, comma. You are not to assume that I mean to make them more important to you than other facts and circumstances, period. There may be times when I overlook the evidence in the case, period. You must supply that evidence from your own memory of what was said, period. There may be a time when I state evidence incorrectly, period. Again, comma, you are the final judges of the evidence and must rely on your memory of what was said during the testimony that was given before you, period. In the same way, comma, what either counsel have said in their respective summaries to you as to the facts or the evidence in this case should have weight with you only as their recollections agree with yours, period. Otherwise, comma, it is your own recollection of the facts and the evidence which should have weight in your deliberations, period, paragraph. Every person charged with the commission of a crime is presumed to be innocent until proven guilty, period. This means that the time at which the defendant was presented here for trial, comma, he stood here before you free from bias, comma, prejudice, or burden arising from his position as the accused, period. That means that so far as you are concerned, comma, he was then innocent, comma, and he continues to be innocent until such time as the evidence and the matters produced here in the orderly conduct of the case satisfy you beyond a reasonable doubt that he was or is guilty, period, paragraph. This requires that if a piece of evidence that is given can be looked at in two different ways, one which is consistent with innocence, comma, then it is to be given that construction, period. The defendant does not have to prove that he did not commit the offense for which he is charged, period. The burden of proof is upon the state that he did commit the crime, period. The presumption of innocence applies to all of the elements necessary to constitute the offense charged, period. If there is more than one element, comma, and this will be defined for you later, comma, all of those elements must be proven by the state beyond a reasonable doubt before you can find the defendant guilty, period. This presumption of innocence, however, does not have the effect of the evidence itself, period. The only effect it has is to place the burden of proof upon the state to prove the charges brought forth beyond a reasonable doubt, period, paragraph. A reasonable doubt is not a doubt that is raised by one trying to find a doubt, period. It is not a guess or a speculation about the guilt of the defendant, period. It does not come from the fact that you may feel sorry for the person being charged with this crime, period. You may not have any sympathy or pity for him or his family, period. A reasonable doubt is one that is based upon reason and common sense and comes from the evidence or lack of evidence in this case, period. A reasonable doubt is one that is reasonable in the light of all the evidence that has been given in this case after you have looked at all of the facts and circumstances set forth before you, period, paragraph. It is not necessary that proof is given beyond all doubt, period. It only must be proven beyond a reasonable doubt, period. Please make sure that you understand that difference because it is very important in all criminal cases, period.